Invoking its inherent powers on constitutional issues, the Apex Court today cleared 10 bills passed by the Tamil Nadu Legislative Assembly, which were withheld by the State Governor Ravi for assent, some for as long as 5 years. A bench of Justices J.B. Pardiwala and Justice R. Mahadevan held that the Governor's reservation of 10 bills for President's assent is quote-unquote illegal and liable to be set aside. The bench also set a time frame of 3 months for governors to decide on assent for bills. Remember, states like Kerala and Punjab, apart from Tamil Nadu, have had run-ins with governors and the setting of time frame and, as far as bills are concerned, and this judgment could be a strong precedent in defining the time frame and role of governors in opposition ruled states. The DMK hailed that judgment as one that is historic and a victory for all state governments.
சற்று முன்பு வரலாற்று சிறப்புமிக்க தீர்ப்பை நமது தமிழ்நாடு அரசு பெற்றுள்ளது. தமிழ்நாடு அரசு மாண்புமை உச்சநீதிமன்றத்தில் வழக்கு தொடுத்ததில் தமிழ்நாடு அரசின் வாதத்தில் இருந்த நியாயத்தை ஏற்று மாண்புமிகு ஆளுநர் அவர்கள் நிறுத்தி வைத்திருந்தது சட்டவிரோதமானது என்றும் அந்த சட்ட முன்வடிவுகளுக்கும் ஆளுநர் அவர்கள் ஒப்புதல் அளிக்கப்பட்டதாக கருதப்பட வேண்டும் என்றும் தெரிவித்து வரலாற்று சிறப்புமிக்க தீர்ப்பினை இன்றைக்கு மாண்புமை உச்சநீதிமன்றம் வழங்கியுள்ளது.
Well, it's a big win for the Tamil Nadu government in the Apex Court. But does this make sure that governors fall in line in several opposition ruled states? What does this judgment really mean from a legal and political standpoint? Joining me this evening, Salem Dharanidharan of the DMK, Kalyan Raman of the BJP, also with our senior advocate of the Apex Court, Ashutosh Srivastava. Thanks to all three of you for joining us. Mr. Kalyan Raman, first to you. The Apex Court has had the last word in what's been a long dispute. It's called the governor's action, quote-unquote, illegal and liable to be set aside. Does this settle the issue once and for all in defining the role and the time frame for governors as far as bills passed by the state's legislative assemblies are concerned?
It's a very strange case to begin with. Number one, the state government wants to usurp the power that is so far enshrined with the constitutional authority, who is the chancellor, that he may be part of the VC appointment process. Okay, and the UGC guidelines says that there must be UGC representative in the search panel. These are the two factors which is to be considered before we arrive at any kind of conclusion or scoring a point, or the so-called victory as claimed by Mr. M.K. Stalin today, which is very unfortunate. Okay. Number one, why there is a need for somebody to keep on passing so many bills without a great reason? Where is the precedence? Where is the example anywhere else in the country? There is no such thing anywhere in the country. And then the DMK wants to waste all the time available in the assembly to score a point over the governor. That's a simple thing. It's a trivial thing as far as the M.K. Stalin government is concerned or the DMK government is concerned. The second time passing is just nothing more than just scoring a point over the governor. Now, the Supreme Court had given its interpretation. Of course, I am not the authority or representative of the Raj Bhavan, so I have nothing much to say it's right or wrong. But on the other hand, Mr. Stalin claiming to have a historical victory is just laughable. It looks like a comedian talking in the assembly. The reason being that the UGC guidelines still insist that there must be a representative by the UGC based on which the national education policy things will have to be, the quality standards must be met, for which there is a UGC nominee. Can the DMK government overthrow that idea and do things beyond this judgment? This is a question for which DMK has no answer still, nor the Supreme Court has addressed the issue so far. So let them go to court again. So
you are saying, no, hang on. You made your point. You are saying, and let me take that to Salem Dharanidharan carefully. While this judgment settles that dispute as far as the governor is concerned, you're saying that the battle as far as this is concerned will continue because of the fact that the UGC guidelines are not what is being dealt with as far as this judgment is concerned. Salem Dharanidharan, go ahead.
So I have only one request from you, that make sure that no one interrupts me. Having said that, the reply of the BJP spokesperson is preposterous at best, because it's a landmark judgment, because it has far-reaching consequences, which says that any state in India, for the foreseeable future, no governor can sit on a bill for inordinate amount of time. Gubernatorial procrastination is not acceptable, is what the learned court has said. In spite of the 10 pending bills, we know how many bills have been kept pending by the governor. And, if the bill, and many bills, at least 20 to 40 bills, have been passed after 6 to 12 months by this governor, which means that what we have to deliver to the people got delayed by 6 to 12 months. Isn't that a travesty to the democracy? What is democracy? In democracy, people are supreme. People elect the MLAs. MLAs in turn elect the chief minister. MLAs sit in the legislature and legislate. What do they legislate? The will of the people. So what comes out of the legislature is nothing but will of the people. How can a governor and appointee sit on it inordinately? In fact, the submission of the Tamil Nadu government was also that an appointee deliberating on a bill, not giving assent, is tyranny, is autocratic. So because he is appointed, he has nothing to do with the people of Tamil Nadu. It's making mockery of democracy. And Supreme Court has rightly come and said, even if you look at constitutional debates, in the constitutional debates itself, when a question arises, if the governor has to be elected, the Ambedkar ji said, no, he can't be elected. He should only be appointed simply because he has only constitutional duties and no functions. If he is elected, he may come and interfere with the function of the elected government. That itself makes it profoundly clear. And as recent as Pere Rivalan case, Justice Nageswar clearly said, governors are nothing but shorthand expression for the State Council of Ministers. Very clear, but this governor has brought disrepute to the position of governors.
All right, you've made your point, and I'm the one who's interrupting you. Nobody else has interrupted you as you requested from the start, but I'm interrupting you because I will now go to the constitutional expert on the panel. Sir, one of the biggest questions has been that there has been no codification and no categorical time frame given to governors as far as deciding on assent for the bill. This is not a compulsion to give assent, but you have to decide on which way you're going to rule on a particular bill that's been sent to you. Does this judgment in many ways put governors on the spot, especially in opposition rule states, and make them fall in line as far as bills which have been duly cleared by legislative bodies are concerned?
Yes, see, if you consider Article 200 of the Constitution of India, it clearly states that if the Legislative Assembly has passed any bill and it has further gone to the governor for his assent, so he has only three choices. Either he can give his assent or he can withhold it, but maximum for a period of 3 months. Thirdly, if none of these two, then he can send it to the President of India for his consent and consideration and for his advice. Nothing other than these three options are possible so far as the constitution of our country is concerned. Now, the idea and behind this is that, the Legislative Assembly is being represented by the elected members, and they are elected by the people of this of the state. And if they elect them, obviously they are going to be represented by these members. And if they make any sort of bill by majority, it is actually the say of the people of that state. And the spirit of the democracy has to be considered. And accordingly, I think the Supreme Court has rightly considered and has gone into the the laws in hand, and it has passed the order accordingly. Because if none of the bills are either given assented to, or if they are just kept in abeyance, then no rule of law can be brought to a state. So I think this is in light with the the consistency of the provisions of our constitution, and accordingly the Supreme Court has rightly considered it and has passed this order, considering the view and the representation of the people at large so far as the democracy of any country is concerned. So I think it is a good move. And if the governor had any issue with those bills, he could have really sent it to the president for his consideration and advice or whatever. But nothing that sort of has happened. So just keeping the bills pending for years and years.
The apex court has dwelled into in that matter, Ashutosh. But thanks very much. You made that point very, very clear. I've got the last 3 minutes left, and I want this to get the political dimension in this. Mr. Kalyan Raman, I know you're raring to go Salem Dharanitharan. Just hold on. Mr. Kalyan Raman, a very, 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 acrimoniously playing out in the state of Tamil Nadu?
See, I am no representative of the governor, so I cannot talk on behalf of the Raj Bhavan or the governor. But the question remains that whatever the historic achievement claimed by DMK is nothing but nonsense. Reason being that there is still UGC intervention on which there is no answer addressed by the Supreme Court. They are simply talking about passing second time, which is what the gentleman, the Supreme Court advocate, I don't remember his name, I'm sorry about it, said that the interpretation has been perfectly given and the governor shall follow it.
Mr. Ashutosh
Henceforth,
Srivastava.
that does not take away
No, go ahead.
the right to have its representative on the search panel based on which the VC can be appointed, and the final say is still with the governor. Thank you.
Salem
Can I
Dharanitharan?
comment, please? I feel very
Yeah,
sad
please,
for
go
R.
ahead.
N. Ravi because I feel very sad for R. N. Ravi because for the last 4 years he's done a very good job as a BJP spokesperson. Now, unfortunately, the governor appointed by the BJP has been hand washed by the BJP spokesperson as well as the BJP Tamil Nadu. Why is this problem happening only in BJP rule states? Tell me this. Why is the gubernatorial procrastination? Sir, please don't interrupt me. I never interrupt you. Why is the gubernatorial procrastination by governors happening only in non-BJP rule state? In Delhi, when Arvind Kejriwal was in power, he couldn't even transfer a pew. That was the state of affairs. And also, see, and again, another problem with the governor is also that arbitrarily sending bills to the president. I think Supreme Court has also highlighted on the matter. I wanted to get the judgment copy before this debate, but unfortunately, I think it's not yet out.
Okay.
But I think I also want to see what regarding the regarding the fact that a lot of bills are being sent to the president by the governors, what they have said about that. But few weeks back, there was a judgment saying bills can't be arbitrarily sent to the president. The clause clearly says only if any bill pass undermines the position of the High Court, only then it can be sent to the president. It's not that any bill and every bill can be sent to the president. For example, look at NEET. Governor took 2 years to send, and president was sitting on it for 2 years. 4 years gone. 80% of a tenure is gone.
Absolutely. I mean, I'm completely out of time. I think the Supreme Court has had the last word as far as this confrontation for the moment is concerned. We'll see how this plays out. Of course, one has to read the entire text of the judgment to understand what it is. It's been hailed as historic by the DMK. We'll see how the road ahead goes on. But thanks to all three of you for joining us here on the Southern View.